is on the ground of what of jurisdiction of this honorable. My ladies and my lord, the first call in determining the present would be Article 87 of the Constitution, which mandates Parliament to enact legislation for timely resolution of electoral disputes. My ladies and my lord, in compliance with this constitutional provision, Parliament did enact the Elections Act. And in Section 7, subsection 4, the Election Act, jurisdiction is conferred upon the High Court to entertain appeals regarding members of County Assembly election petitions. And then Elections Act goes silent. So the bone of contention that arises is where an act of Parliament is silent with respect to the jurisdiction of this court. The question is, does this court jurisdiction, in the absence of an express provision by an act of Parliament? My ladies and my lord, it is a submission this morning that where an act of Parliament is silent, then the Court of Appeal does not have jurisdiction. My lady, there is a long chain of authorities from this court. The same they are to be found in paragraphs 11.1 up to 11.7, authorities by this Court of Appeal, where every time this matter has come up before this court, way back since 2013, 2017, and now the court has consistently held that it does not have jurisdiction to entertain second appeals regarding members of County Assembly. Now, my lords and my ladies, this being Court of Appeals decisions, you are at liberty to depart from them. However, the question of this court's jurisdiction with regarding to MCA appeals was conclusively determined by the Supreme Court in the case of Hamida Yaroi Sheikh Nori versus Faith Tumaini Kombe and two others, where in the Supreme Court expressly held that in the absence, and this, my lord and my ladies, is to be found in paragraph 33 of the Supreme Court decision. The Supreme Court expressly held that in the absence of an express statutory provision, no second appeal lies to the Court of Appeal from the High Court regarding members of County Assembly election petitions appeal. Now, my ladies and my lord, in interpreting Section 75, subsection 4 of the Elections Act, whichever rule of interpretation that the court adopts, be it the literal rule, be it the golden rule, be it the mischief rule, be it the purposive rule, the inescapable conclusion that the court ought to arrive at is that Parliament intended that parties would have only of appeal, such that for MCAs they will only the High Court to the Court of Appeal. My ladies and my lords, with respect to the other issues, save for the presidency, the members of Parliament, senators, reps, and gubernatorial can equally have only one layer from the High to the Court of Appeal. Now, we do consider that in very exceptional circumstances, then would these other four elective positions find their way to the Supreme Court. And this is to be understood against the background that in yesteryears, prior to the 2010 Kenyan constitutions, where election petitions would drag throughout the entire 5 years term. The reason as to why the premise of the constitutions of the 2010 Kenya constitution intended to have parties to have only one layer of appeal. So, my lord, with respect to the jurisdiction of this court, it is our submission that parliamentarians, they were very deliberate in having Section 75, subsection 4 of the Elections Act to be silent with regard to MCA appeals. The same was not by mistake. but the same was deliberate. Now, my ladies and my lord, you will be referred to by the counsel for the appellant a decision in the DHL Excel case, and the appellant's position is that simply because the matter is from the High Court, then it can find its way to the Court of Appeal. My lord and my ladies, we submit that this is not the correct position because we have section 87 we have article 87 of the Constitution, and we also have article 164 sub article 4 paragraph 3. Now, my ladies and my lord, we cannot have two constitutional provisions which are inconsistent. And indeed, we submit that these two provisions, they are not inconsistent. So the long and short of our submissions with respect to this ground of the application is that this court jurisdiction, and by virtue of the binding Supreme Court precedent in the case of Hamida Yaroi, this court ought to down its tools alone and award costs to the first respondent. My ladies and my lord, there is also a second ground, this being that the notice of appeal was never served on the first respondent. My ladies and my lord, we rely on Rule 7, Sub-Rule 3 of the 2017 Court of Appeal Election Petition Rules, which provides that a notice of appeal, it provides in mandatory terms that it ought to be served directly or by way of publication in a newspaper with nationwide circulation. However, my lord, the notice of appeal was served up the advocates for the first respondent by way of an email. My ladies and my lord, the said email is annexed as annexure MK01 in the first respondent's annexures. So, my lady, it is asserted that service by way of an email is not a recognized mode of service with respect to a notice of appeal as envisaged in the 27 rules of this particular court. My lord, we submit that the failure to properly serve the first respondent is a fundamental issue. Reason being, my ladies and my lord,